Welcome back to Open Line, talking with elder law attorney Tim Takis. And I wanted to move the discussion toward wills.
Right.
I'm always interested in this.
Yes.
You know, and I bet you see, well, because people come to your office, they don't have these problems, but you see
Hopefully
disasters.
Yes.
People that don't have a will, or a will that is contested, and families are torn apart.
Right. Yes.
So, you know, what are
hopefully, hopefully they're not coming into our office, because if they do, it's like, you know, you need to go hire some other lawyer, because, you know, now you're going to be litigating over that lamp or that sofa that you thought that mama gave you.
Which
you
is
know, and
terrible.
of course our job is to try to make sure that those problems don't come up.
Right.
You know, but you're right. I mean, I was telling a family not too long ago is that I had a case, oh gosh, it was probably been at least 30 years ago, when I was just a little baby lawyer.
Baby lawyer.
You know, and there was like nothing in this estate, but like less than $10,000 in this estate. But the family litigated over the personal property.
Mm-hmm. So they blew away the $10,000.
Yeah.
They lost that.
Yeah, they lost that. I mean, they're just like, okay, you know, they didn't, you know, it was all about the stuff. And one of the things that I learned about that is a number of things that I've learned is that one of them is that when we do our estate planning, when we do our wills, is that people come in and they say, well, I've got a list of stuff here. I want you to put this in the will that you're drafting for me. Okay. So it's got, I want to give my antique sewing machine to this person, and the diamond ring to that person, and on and on and on. It's like, I'll say, no, I don't do that. I don't want to do that, because personal property is what I call ephemeral. Mm-hmm. It comes and goes. You know, because what's likely to happen is that you know, whatever it is that you have, that vase or whatever that you wanted to give to your, that you say that in your will goes to your daughter, you know, well, before you died, maybe it broke. Right. Or you gave it to somebody else. And then when you die, you know, your daughter shows up and goes, where's my vase? You know, and then your the brother-in-law says, well, your mom gave it to me. Oh boy. Yeah. You know, I've been taking care of her all this time, you know, and she said, I really wanted you to have that vase. I was promised it to my daughter, but, you know, she doesn't come around, you know, and now you have a lawsuit. Oh, no. Yeah. So what I tell people is, I say, get a sheet of paper, just like what's over there. Right. And you sit down and you write it out in your own handwriting, and you sign it and date it. And that's how you bequeath personal property, not cash, not real estate, not stocks or bonds or whatever. You know, so, and sometimes I will tell people, I'll say, okay, get a sheet of paper for each person. Okay. I had one client that she did 2 or 3 of these before she passed away. Okay. Yeah, because we instructed her years and years ago. She says, you know, we don't want you to, we're not going to put all that stuff in your will that we're going to write for you. You know, we're going to do the other stuff in the will, but you do the personal property. And sure enough, she had started one list, and then she said, I don't want to do this. And so she threw that one away, and she did another list. And we knew that was her second list, because people change their mind. Right, right. You know, and what happens is that people go, well, I've got all this stuff listed in my will, and I don't want to do that now. So, and I know if I go back to that lawyer, he's going to charge me a fortune. Right, right. That's what happened. Leave it. Yeah, I think you're right. And so what they do is that they pull it out and they start scribbling on it. Mm-hmm. You know, and they mark on it and whatever, and that doesn't work. Yeah. I had that case too, where we had a client that did that, and you know, the daughter brought her will in years later, and it was on one of those 9-pin matrix printers that it was done. You know, all this kind of writing or whatever that was on it, and so I took it to Judge Clement here in Nashville. And I said, Judge, in my opinion, you should ignore everything that is not typewritten on this will. Okay. I mean, it was scratched on all over, and the judge says that's exactly what the law is. Mm-hmm. Because we don't know who did the scratching. Sure. I mean, the will was a valid will, mm-hmm. even though it had been marked on and whatever. So we could see everything, the judge could see everything that had been somebody who had been marking it out. So the judge says, I'm going to admit that will. You know, and we're going to ignore everything that's been written on it. Wow. You know, and that's what people, you know, so we always say is get the piece of paper and write it down, you know, if it's personal property.
And then that goes with the will.
And that goes with the will.
Yeah, that makes perfect sense. And
you know, the technical legal term for it is a holographic codicil. You know, it's like the all-to-ma that we've talked about on the envelope that you've written out. All somebody has to do is prove that, yeah, that's in mom's handwriting. You know, she signed it and dated, and it was all in her own handwriting, you know, and the judge is going to say, yeah, that's a holographic codicil, you know, and this is a disposition of personal property.
Yeah, you've said sometimes people, you know, I don't want to say think too much about these things. I mean, you should think about them a lot, but property will pass. And we can talk about, I want to take a call here. We can talk about that, how it will pass naturally. But yeah, it's a fascinating topic for me. Let's go to Lucy. Always good to hear from Lucy. Hello, Lucy.
Hey, y'all.
Hey.
Hey, I want to say something quickly about pre-existing conditions. About 15 years ago, I was trying to get some private health insurance, and they went through a questionnaire list, and one of the things the guy asked me if I'd ever been treated for depression, and I told him no, and I asked him why he would ask that. He said, I'll tell you at the end of the interview. And at the end of the interview, he told me, he said, if you had answered yes, I would have not insured you because a lot of these antidepressant medications now lead to diabetes down the road, and we've quit insuring people.
Oh, my goodness.
I'm like, you're serious. But anyway.
Wow, that's crazy.
Yeah, so if you're 45 and you have early onset Alzheimer's, you've been treated earlier for depression when it was actually Alzheimer's, your rates are probably going to be out the roof if they change all these Healthcare Reform Act laws. But anyway, my question is about irrevocable trust. Can you give me a rough idea how they're priced by an attorney, how they range in price, and how that goes?
Okay, so an irrevocable trust.
Thank you, Lucy. Yeah, okay, so I don't know about that.
So I think what I heard Lucy say was not an revocable, but an irrevocable.
Irrevocable.
Irrevocable means is that, you know, I have money or property, you know, and I have a trustee, someone who is going to hold this money or property. You know, okay, so that's Ben. You know, so I give it to you, you know, and you have, you know, I look back here, there's like a roll or a bun or a old sandwich back here. I was going to give that to you. So you hold that, and you're holding it in trust, and you're holding it for somebody else, not for me, because what makes it irrevocable, it means is that I can't get it back.
Okay.
I have to give it to you, and you're holding it for the benefit of somebody else. Maybe a child, another family member, you know, maybe somebody, you know, but I can't get that asset back. That's what makes it irrevocable. Now, what is the cost of that? Usually in our situation, you know, when we're doing estate planning for people, we never, I can't think of any time we have ever done a trust that is not a part of some over estate plan, a comprehensive estate plan.
Okay.
You know, if you go to see a lawyer and you say, well, how much do you charge just for a trust? The lawyer should say, I don't sell trust. We do estate planning.
Yeah, you wouldn't do it just by itself.
Right.
It would be part of a comprehensive
package.
Okay.
So,
sure.
You know, you're likely to, you know, depending, and a lot of it depends upon, you know, what are you trying to accomplish by setting up a trust? Do you have a taxable estate? Do you know, is the person that you're setting up the trust for, does that person have special needs?
What are you generally trying to accomplish when you set one up? Is it to help a kid who has maybe special needs?
Could be maybe a child with special needs. Maybe you're doing it for tax planning. Maybe you're doing it for asset protection planning because you're worried that if I have to go to a nursing home, then then they're going to count that asset as a resource to me, and then so you have to do other things. So I hate to sound vague or ambiguous, but it's kind of like, well, how much do you charge for a car?
Yeah.
How much do you charge for an automobile? It's like, well, it could be, what kind of automobile do you want? And so that's why I just don't like.
That's a hard. It's a hard question.
It's a hard question.
Exactly.
Yeah.
But it could be done reasonably if you go to a lawyer, ask them.
Yeah, exactly. And the way we do our representations is that we do all our representations by a flat fee. So we don't charge you by the hour, we don't charge you by the document. In other words, you know, our job is to assess what your needs are and what your goals are, you know, and then together we'll work on, okay, this is what it looks like we'll do for you to accomplish your goals, you know, and the fee's going to be X. I mean, that's, you know, so, you know, and so we're not, so if somebody says, well, I don't really want that plan, right, you know, that's too expensive, we'll say, well, you know, maybe it is, but, you know, it's kind of like, but it's what you want and what you need to accomplish your goals.
Always interested to learn about that stuff. And Lucy, okay, thank you for that call, irrevocable trust. Yeah. You know, back to what we were talking about as far as estate planning, as far as a will and that kind of thing. Yeah. The battles that people get in. Right. And but property will pass without a will. Right. Right.
Yeah, we've been doing it for, people have been dying for centuries, and somehow it gets over. Yeah.
And there are laws that indicate what's going to happen.
Absolutely. Right. So if you die and you don't have children and you have a spouse, everything goes to your spouse.
There you go.
If you die and you have children and you have a spouse, then everything does not go to your spouse, and everything does not go to your children.
Is it half and half?
Well, there's a formula for how that's done, but basically figure if you have 3 children, right? You know, and you know, and then you die without a will, and you own property just by yourself, you know, then your spouse is probably going to get equivalent to a child share.
Okay.
You know,
and that's automatically. Now you could write in the will something different.
Yeah. Okay. You could leave everything to your spouse, and then, you know, and then of course, you know, then when she remarries, when she remarries her boyfriend, you know, then it's you know, so you have those kind of things come up.
That's when the kids get really upset.
That's when the kids get really upset and go, well, the family farm just went out of the family. It went to somebody else's family. Right. You know, because daddy died and left everything to the, to his new wife, who then turned around and remarried, and then she died and left everything to, you know, a stranger.
And daddy was not of the right mind when he did the will. That's what they all say.
That they all say, yeah. Yeah. So, or he didn't have a will because thinking that, well, when I die, it's just going to go to my kids.
Oh boy, yeah. Well,
it's
that's
like, no, maybe not. You know, you are married and you don't have a prenuptial agreement, so you can't disinherit your spouse, not without her consent. You know, and so she's entitled to a share of your estate. You know, an absolute share, so you can't just like say, you know, well, you know, it's mine. You know, when we married, she knew that I owned this farmland, and she's told me she wouldn't, you know, she had her own property. Right. So she didn't want anything. Well, maybe yes, maybe no.
So you have something like a piece of property, and you have a wife and then 3 kids. Would you have to sell it? Or would you just divide, if it's 100 acres, you just divide each by, one is going to get, you know, 20 acres, 20 acres, 20 acres. Yeah. I mean, is that how it goes?
Well, usually what happens is, as a judge often will say, is that cash is easy to divide 4 ways or whatever. Now, but if they can't agree, the judge is going to, and somebody files a suit, which they have a right to get their share, you know, there is a really great likelihood that a judge isn't going to try to say, well, you're going to get the front 40 and the other 3 are going to get these assets, because the judge is going to go, if you get to my court,
then it's pretty bad.
Then it's pretty bad, you know, and I'm going to order that this property be sold, and we're going to divide the cash. You know, otherwise, if the parties don't agree on a division like that, you know, then the chances, you know, a court can divide what's called partition in kind, which means they can literally divide acreages, but
that's tough.
That's so unusual. In fact, I don't think I've ever seen that.
And we've had some calls before from people who are just in the midst of terrible battles. Right. And so, again, all right, so someone marries someone, and it's in the will that it's going to go to the new wife. Yes. And say there's somebody out there that has that situation, and they're a child and they feel wronged. How do you then deal with that? How do you fight that? Do you have to show they're not of their right mind?
Basically, what you have to show is that they lack capacity. I mean, there's a, you know, the law presumes that everybody has the legal capacity, the mental capacity to execute a valid will. Okay, so the presumption is that, how do you overcome that presumption? One is that you simply lack the appreciation of knowing what you were doing, okay? Oh, sign this piece of paper. Well, what is that? It says like, well, we want your autograph because you're a famous person, you know, and the person thinks they're famous, so they sign it. They lack capacity. Or,
but if
the other thing is they're under undue influence by somebody.
Oh, okay. So now they're operating their house. I mean, so they're married, they're paying their bills. It's hard to argue that they are.
Yeah, they're not. I mean, that's a really hard.
They're just in love.
Yeah, exactly. And they say, yeah, I mean, okay, you know, when you marry somebody or you're in love with somebody, you know, yeah, that person has influence on you. Okay, now the question is not influence, or whether it's undue influence. You know, and that's kind of one of those things. That's why, you know, that's what trials are made of.
Right.
You know, as people go into court and say, well, this is what happened. You know, Daddy, you know, he always promised that property to us, and he married this person, you know, and she convinced him, you know, to do whatever. And it's like, well, you know, how much of that influence is undue influence?
Undue influence. How do you find it? All right, let's take a couple quick calls here. Let's go to Gertrude. Hello, Gertrude.
Mm-hmm.
Yes, ma'am. Go right ahead.
I was wanting to know the benefits of going with a trust instead of a will. I like to do something that I don't have to go to court again. Don't want my children to have to.
Well, that's what we use a trust for. Now, here's how property passes. Okay, you heard Ben talk about, say, well, what about the way property passes? One is property passes by operation of law. So if you own property as husband and wife, or joint tenancy with a right of survivorship, it means when, okay, husband dies first, everything that I own jointly with my wife now belongs to her by operation of law. Or if you have a bank account with a child and it's a survivorship account, which means whoever dies first, the survivor gets the account. That's by operation of law.
Okay.
And of course, also by operation of law, if you die without any estate planning, it goes in a certain way by law, by operation of law. The second way property passes is by a contract. You have a life insurance policy, you name a beneficiary, that's a contract that you have with the company to pay somebody. You have a bank account that's payable on death, or a retirement plan that's payable on death to somebody. That's a contract that you have with the bank or the insurance company to pay that person when you pass away. Or there's also an instruction, a statement from the testator, the person that's making, and that's a will.
Okay.
Just a simple statement. Now, what a trust is a contract.
Right.
It's a contract that you have with a trustee, so that says that when I die, those assets that are in your hands, you're going to pay out to somebody else. That's what a trust is. And those assets avoid probate.
I don't see why that's any different than a will.
Well, because the will, what you have to do is you have to take that piece of paper and you say, okay, Judge, I found this on Mama's paperwork, and it says, all to me, or all to Tim, and then the judge has to decide whether, Mom, that's actually the statement that she made, how she wants her property to go. And that's called probate.
So it sounds like if she wants to avoid court, she should do a trust.
She'd do a trust.
All right, we have to take a break. If you're on the line, hold on. Robert, Amanda, anybody else on the line, hold on. We'll take a break. Be back right after this.